Good morning also from my side, and welcome today's morning panel with our three distinguished lecturers. We will have three lectures, each approximately 20 minutes, and afterwards we will have discussions. And I would like to introduce our first speaker, Professor Bernhard Schima. Professor Bernhard Schima is director at the European Commission's Legal Service, and he's in charge of two teams at the moment, one for civil service law and the other one for the area of freedom, security and justice. But he's not only a high-ranking civil servant, he is also a distinguished scholar, and if I remember correctly, he received his habilitation in 2004 from Graz University, and he is honorary professor for European law at Vienna University for Business, and I think it's administration. I don't even know the English name of your university. And he has published. I'm very sorry. And he has published numerous papers on European law. Please join me in welcoming Professor Bernhard Schima here at our panel.
Thank you very much, Iris, for the kind introduction, and thank you all for the warm welcome. Good morning. I would like to start my short presentation with two important disclaimers. Firstly, it is true that I work for the European Commission, but everything that I say here, I say in an absolutely personal capacity, and it can in no way be attributed to the European Commission. The other, also quite important disclaimer, is that, as you may have heard, I'm working in two different subject matters in particular right now. Digital services and regulation of the digital world is not one of them. So what you hear from me, you hear really from the perspective of a general EU lawyer and not at all of a specialist in the area that I'm now going to talk about. So with that, I would like to take us this morning more or less quickly to a point on which I would like to cast a spotlight, namely how the Digital Services Act deals with particularly big players on the market. And I would like to take us there, first of all, by, okay, now I need to turn this on. And here we are. By highlighting that the Digital Services Act, in spite of its name, does not regulate all digital services, but only one very particular type of such services, which it calls intermediary services. And intermediary services are what is then further defined in the Act as mere conduit, caching, and hosting services. Broadly speaking, those are all services involving the transmission and storage of user-generated content. It covers video sharing platforms, online marketplaces, blogging, websites, social media, and internet access services. A common feature of all those services is that the service provider generally acts passively with regard to the content that it transmits or stores. And that is important for the type of regulation that we are going to see the union legislator has provided for. What is also very important as regards to scope is that the Act applies to service providers, to all services actually offered in the European Union, regardless of the origin of the service. Then, of course, it's a question how you define, and the Act does that, when a service is actually offered in the Union, sort of the accidental use of a service by someone who doesn't actually want to offer it in the Union would not come within that scope. But whenever something is actually offered in the Union, the Act will apply, no matter where the company is established. The objectives that the Digital Services Act wants to achieve are, as it says itself in its recital 9, by the way, I mean, the Digital Services Act is one particularly thoroughly reasoned piece of legislation, I would say. I mean, at least lengthily reasoned, yeah, about the thoroughness one may perhaps debate. But this is 100 pages in the official journal, and 40 of those 100 pages are the recitals, yeah, the reasons that the legislator gives for adopting this piece of legislation. And what the legislator, in broad terms, and there are many complements to that, of course, says is that it wants to ensure a safe and predictable and trusted online environment. And then, and perhaps most importantly, it wants to address the dissemination of illegal content online and the societal risks that the dissemination of disinformation or other content, dangerous, harmful, potentially harmful content, may generate. It wants to guarantee the respect of the fundamental rights that are guaranteed in the Charter of Fundamental Rights. And it wants, at the same time, to facilitate innovation. And here I can already sense room for discussion whether it manages that, but that is perhaps not going to play such an important role in the topic that I'm going to cover here, because we are actually dealing with the big players who are perhaps best placed to adapt to the most stringent legal requirements. The Act follows an internal market logic, which means that the legislator has observed before passing this legislation that the member states have started to regulate or are likely to start regulating within this particular area to introduce laws, in particular on diligence requirements for providers of such intermediary services. The risk where different member states start regulating this in different ways is, of course, that this is going to create disturbances, obstacles to the internal market, which is the justification for the union legislator to pass harmonizing legislation to facilitate free movement, to facilitate the free provision of services in the internal market. And what it does, and that is also very important, is that it fully harmonizes the conditions for the provision of intermediary services as regards the objectives that it mentions. Which means that where a service provider complies with the various provisions laid down in this regulation, which is what the Digital Services Act is, its provision of services cannot be hindered in any way by national regulations aiming at the same objectives. So there's full harmonization as regards the objectives that I've just talked about and that the Digital Services Act pursues. There may be other objectives that are not touched upon by the Act. Turning to the substance, there are two big elements, broadly speaking. The first one is that the liability of providers of such intermediary services is limited. That's one big chapter of the regulation. And that is done because, well, as said in the introduction, intermediary services are not themselves generators of the content, which is why it is justified to limit their liability. The counterpart to this is that you impose important due diligence duties on them. So they are not the generators of the content, but nevertheless they host, they transmit this content, which is why they take a certain responsibility, and which is why those due diligence obligations are imposed on them. And the way the Act does that is quite interesting because it has a layered structure. There are 4 different layers of obligations imposed on the providers of such intermediary services. A basic layer of obligations which is imposed on all of them, such as transparency, reporting, duties to cooperate with the authorities, duties to nominate, to appoint a point of contact, for instance. Then there are additional obligations that apply to all hosting providers. Hosting services in general, also those that are not platforms. Platforms are those where the information that is hosted then becomes accessible to the public. Hosting services are those where that is not necessarily there for public dissemination. But already simple hosting services will have further obligations than compared with all the others. In particular, a notice and action obligation. So if you tell the hosting service that a certain content that it hosts is illegal or harmful or whatever, there will be a duty on that hosting service to react to such a notice. Additional obligations, that would be then the third layer, apply to providers of online platforms and online search engines. So this is where now the information that what is stored is there for public dissemination. And those, for instance, have to have a complaint and redress mechanism. They have to provide for a possibility of out-of-court settlements. All these, there are a number of additional obligations that only apply to those. And finally, and this is where I would like to get, there is the layer of enhanced obligations which apply to providers of very large online platforms and very large online search engines. And this is now the topic that I would like to focus on. The first question is how the Digital Services Act defines those very large online platforms and very large online search engines. I will focus only for reasons of simplification now on the platforms. They are really simply defined by size. Namely, they must have a number of average monthly active recipients of the service in the Union that is equal to or higher than 45 million. That figure doesn't actually fall from the sky. It corresponds to 10% of the Union population. And that is also what the legislator explains in this case, recitals 75 and 76 of the Act. Where that is the case, whether that is the case must be assessed by the European Commission. And the European Commission adopts designation decisions of these very large online platforms. For that to happen, the platforms had to provide data on their use to the Commission, and the Commission could also ask for more information, and then finally the Commission says the Act is in any event enabled to use any information at its disposal to reach the conclusion that a particular online platform is very large and needs to be designated. Now this is what actually, and the reason for that is, and that I think is also important to note, that those platforms are supposed to pose the highest societal and economic risks. They typically have a pan-European presence and have become de facto public spaces which play a systemic role for millions of businesses and citizens. So the Commission was tasked to designate those flops, and it has done so in one first batch of decisions that were adopted on the 25th of April this year, and which covered the platforms that you see here. And you will notice that most of them are indeed non-European companies. I believe the only European player here is Zalando, right?
This is why they are already suing.
Yeah. But they're not suing because they're non-European, I would say. But
Zalando is suing because they are stating that they are the only European, and that's unfair.
Ah, yeah, okay. Yes. Okay, I mean, here at least we can say that we are not necessarily making life more difficult for all the European players and letting all the others go scot-free. That is perhaps also one message that might not be so useless to pass in the light of how the discussions have gone previously. So what happens when you have been designated as a flop? You need to carry out a risk assessment. There's an entire chapter or section of the Act which tells you what you have to do. You have to carry out a risk assessment, and we are going to get to that in a second, because I think the features that this risk assessment must contain are actually quite telling and quite interesting. Once you have identified particular risks, you need to take mitigation measures, and in case a crisis arises, a public security or public health crisis arises, which is also something which is rather precisely defined in the Act, the Commission can impose quite serious mitigation measures on the very large online platform, which can really interfere quite significantly with how those platforms conduct their business. They must have an independent audit carried out periodically, I believe annually, as regards the risks they have identified and how they deal with them, so an outside audit. They must comply with specific rules on recommender systems, which is perhaps one thing at which one should also look briefly. A recommender system, says the text, is a fully or partially automated system used by an online platform to suggest in its online interface specific information to recipients of the service, or to prioritize that information. So, I mean, we've all seen this. You get, when you search a product, when you search something, you get related recommendations. And when you are a very large online platform, you need to propose to your users at least one alternative recommender system that is not based on profiling. Profiling is defined in the GDPR, the General Data Protection Regulation, as a form of automated processing of personal data, which consists of the use of personal data to evaluate certain personal aspects relating to a natural person, in particular to analyze or predict aspects concerning that person's performance at work, economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. This is something that people are concerned about, which is something that I would personally fully understand. And therefore, very large online platforms are required. First of all, I mean, people need to know that a particular recommender system is based on profiling. And where that is the case, they must propose an alternative. And possible alternative being simply, the relatedness of a particular, the objective relatedness of a particular alternative product to your search. Like, for instance, when you search for volume 1 of a particular book, it would not be qualified as profiling, normally, I would say, that the search proposes you volume 2, right? By contrast, where the recommendation is based on the fact that you are searching from a particular country, from a particular place. Yeah? This is something that would rather fall into the category of profiling, and which is something that the user is entitled to ask to be excluded in those cases. So that's Article 38 of the Digital Services Act. Article 39 contains another significant obligation, namely additional advertising transparency. So when you have been designated, you need to have a register, basically, of anyone who places ads on your platform, and a number of details about those ads sometime into the past. And that must be something that the user of the service can search rather easily. So that's another relatively serious and strict obligation imposed exclusively on those designated very large online platforms. What is, I think, particularly interesting are the risks that have to be taken into account in the risk assessment. So first of all, there is the dissemination of illegal content. Yeah? Is the service likely to be used for the dissemination of illegal content? And then secondly, what are the possible negative effects for the exercise of fundamental rights? And here we have, in particular, so this is not a limited list, human dignity, private and family life, protection of personal data, freedom of expression and information, equal treatment, non-discrimination, the respect of the rights of the child, and also a high level of consumer protection. So the argument for regulating here is not really that we want necessarily to bring fundamental rights into play in the relationship between different private actors ultimately. So this is not necessarily about the horizontal effect of fundamental rights, but it's rather about the fact that states want to protect those fundamental rights, and states feel that they have a duty to protect those fundamental rights, and rather than allowing them to do so individually, which would be detrimental to the internal market, we do so in a harmonized and exhaustive way to ensure that once that high level of protection of the fundamental rights in question is reached, this is also sufficient for the service providers to carry out their activity. There are also other effects that need to be taken into account, namely effects on civic discourse and electoral processes. I mean, all this goes back to quite a number of experiences that one has had in the past with such very large, or with online platforms in general. Indeed, and that's now going to be the last point that I would like to make, as Nikki has already hinted at, this is a possible source of litigation, of course. You may want to, when you're a company and you find yourself confronted with these very serious obligations that are different from those imposed on less important actors, on actors considered less important or less risky than others under the regulation, well, you may not like that, and you may want to challenge, on the one hand, the question whether determination has been made correctly. So do you actually have 45 million users over a particular period? Has the calculation been done in a correct way? And this is indeed, as I understand, because I mean, this has not everything is in the public domain, but what we do know now is that Zalando and Amazon have both challenged their designation as very large online platforms. So they received these decisions from the Commission back in April, and in due time they, I believe at least, they brought actions against this designation, saying in the case of Zalando that they are not very large, and saying in the case of Amazon, essentially that marketplaces are in a different situation from the others and don't create the same systemic risks as YouTube or Google and so on. So that's in a nutshell what sort of has transpired from the arguments made by Amazon, but again, not a lot of this is in the public domain. We have some press statements and so on, but not much more. So what a very large online platform or search engine might invoke against such a designation in one way or another, and then one can discuss, of course, in what way that can be done in litigation, but that's probably not for here, is that their fundamental rights are, of course, also impacted when they have to comply with all those obligations. Yeah? They may say that there is an issue of equal treatment, so what really distinguishes are the biggest ones from this line above the line, sort of really objectively in a different situation. Is an online marketplace really in a different situation from an online trader that trades basically in its own products so to speak? So those are questions that one may ask. There may be answers to those questions, of course. But those are things that entities might want to rely on. They themselves may want to rely on privacy, protection of business information when it comes to this advertising transparency. This is something that one could also imagine they would find interesting. And then, of course, there's freedom of expression and information. Their freedom of expression and information. There is the freedom to conduct a business and their right to property. All different elements, different fundamental rights that need to be thrown into the balance together with the fundamental rights on the side of the users of the service that one wants to protect. And with that, I would just like to put on the screen also 2 sources that I have used, 2 articles that can also be found online, both of them. And I think I will leave it at that, and thank you very much for your attention. Oh, sorry. Too quick. I can put that back on.
So thank you very much, Bernhard, for this very interesting introduction into today's topic. I will now introduce today's second speaker, Dr. Klaus Steinmaurer. He's director at the Austrian Regulatory Authority for Broadcasting and Telecommunications and in charge of telecommunications and postal services. Before joining the Austrian Regulatory Authority, he held numerous leading positions in industry, both in Austria and abroad. Furthermore, in 22, he was vice chair of the board of the European Regulators for Electronic Communications. And since 2023, he's the member of the DMA high-level expert group. In addition to his very impressive and broad experience in practical experience, he is also very active in academia. He has been lecturing at numerous universities, amongst which he has been lecturing, I think, since 2011 at Vienna University on international telecommunications, and he has published widely in the field of regulation, data protection, and compliance. Please join me in welcoming Dr. Steinmaurer.
Mitnehmen? Okay. Das ist so schlecht. So. Okay. So.
I will stop you once you reach 30 minutes. You told me before.
No. Okay, I try to make it short because thank you and good morning. It's a great pleasure to be here. Mrs. Eisenberger already introduced me, so I can start immediately. And I will come to what Mr. Schima already said. He explained us about the DSA. And as you saw, it's a very huge legal work which has to be done. There's much background to know, and it's necessary that some authorities, some bodies do the work which is written down in the DSA. So, but that's the DSA. On the other hand, we also have the DMA. As you mentioned, I'm also in this high-level expert group in the Digital Markets Act together with the European Commission. There's the Data Act, which was already published by the government, by the Parliament. There's the AI Act, which is now discussed very broadly in the public. There's the Data Governance Act, and as you know, the European Commission was very hard working on making many regulations in the past, I would say 5 years. So that's was what my impression was. For a long time, and I work really for a long time in regulation and in this field of law. I can say I never experienced such a time where so many regulations at once came up to us than in the past three to 4 years, I would say. So I think it started with the GDPR, and I would always say regarding data, GDPR is always the mother of everything. And if you read the other acts, you always read there's always one sentence at the end of the Artificial Intelligence Act. You see the last sentence, it is, okay, it does not impact on the general GDPR, which is, personally said, and I must also make this disclaimer, what I say here, I'm saying as Klaus Steinmaurer and not as the regulator, and it can be not seen as the regulator's opinion at all. But coming back to that, it's really clear that there's a huge bunch of regulation now in the field. So what we are doing, and that's why I say, okay, I'm not now telling you and talking with you about regulation for a specific field and legal question. It's the regulation in general and more the organizational question about it, and which are the competent authorities who do all this job, nationally and on the European side, who can manage this. And it's the first thing I can tell you, it's not clear till now. So that's what I want to say. So what we had yesterday, this discussion about regulation in general, where you said, okay, it's over regulation. So how can we develop a real good legal regulatory framework for the future, which helps also industry and consumers to come forward? So that's what regulators are thinking about, and that's what I now want to tell you. Just coming to these points, I already mentioned it. The future of regulation, what's needed. We know, and I mentioned it, data law, new data law explained, the Data Act coming up. We have draft regulator reached political agreement. We had regarding AI law, we had the discussion regarding AI regulation. What's very interesting, EU, the European Union, always mentions we want to be the leading in regulation. So that's, you also mentioned it yesterday. The EU always says we want to be leading in regulation. And I have been to the US this April on the West Coast, and we had many discussions. And many companies there told us, yes, it's very, very, very fine that the European Union is working on an AI Act. We are expecting, we are waiting for it. Yes, it's great what you have done with the GDPR. But that's also then the US guys mentioned. It's nice. We will take a look at it and we will take that what we think it's fitting for us, for our businesses, but we don't want to take all of this for us. And so Europe is making a work, and the US companies, and I think also in other parts of the of this world, they will look at it. It's a good work, but at the end, I would always say this: we are leading in the regulation, and the US are thinking to be leading in the business. So that's a bit the difference we are talking about. What we see now is, and what you also have to recognize when we are talking about regulation in this field, it's now all about data. It's about data competition, not like it was in former times, and like I also worked very long in. It was in former times it was more the infrastructure competition, to build up the infrastructures, to break up markets. The old regulation was more focused on breaking up existing monopolistic markets and make by this regulation and I would also say deregulation a bit, make it possible that new businesses are developed, that customer welfare increases, that innovation comes to the customers and to the businesses. That was more the focus of regulation, I would say, in the 90s and the first part of the 2000s, of the 0 years. So that was a bit what we now have. It's not only the breakup of the existing markets. Now we have to develop and maintain new markets. There are new markets coming up. This data is all part of a market development, so therefore regulators have now to think, how can we maintain the existing framework, the existing legal securities we have? How can we avoid risk? How can we build up a regulatory framework for something we don't really know what is coming? So that's, before we know what was open, we had a clear target. Now we don't know what will come, and so therefore that's the question we have to look at as regulators, and that's one of the big discussions we have on the European level with all these regulatory groups. I don't know if you all know this. There are special regulatory bodies on European side. There's the BEREC, that's the Board of Regulators for Electronic Communication Service. That's where I'm part of. There's also this ERGA, that's for the media regulators. There's and all the other regulators also have some bodies, while the BEREC is one of those bodies which is most developed because it has an own office in Riga, and it's very broadly, it's just very close to an agency. And we will see that there will be also some developments bringing these bodies to European agencies, because one thing I can even say at the beginning now is that the national regulation will decrease, I would say, will become less important compared to what have to be done on the European level. But we are asked, and we are really challenged to bring in our experience on the European level much more than we had done it till now. And coming back to the DSA you mentioned, there's this question. The European Union said, okay, there should be a competent authority at the end on national level, which is very close to the European Commission in this group. And this competent authority, they call it the so-called, how did they say it? If there are several authorities perhaps competent, there should be one coordinator. And that's, I think, also the new system of how the European Union designs the regulation organization, where they say, okay, if there are several competent authorities in one country, there should be a coordinator, so-called digital service coordinator. Regarding the DSA, the national law is underway, I would say. It will come. I think in autumn we will have I think even mid of August, they told us that there will be a consultation on the law regarding the DSA, and there will be the Com Austria, the communications authority in Vienna, which is part of RTR, will become the digital service coordinator for Austria, but mainly focused, and you see it when you hear what Dr. Schima said. It's DSA is regarding content, it's regarding liability of the content hosts and so on. So therefore this is the question, so therefore it's the right thing that it's mainly on the media side to have this coordinator, but nevertheless there will be also partly competences of the Data Protection Authority and also partly competences of us as the telecoms regulator to be brought in, and that has to be coordinated. So that's the approach. I will come back to that a bit later, because that's one of the main things when we think about regulation in the future. So just make a short overview on what I say. I already mentioned it, that the European data strategy aims to make Europe a leader in the data-driven society. We have many rules, and the rules are in particular regarding privacy, data protection, and competition law. It's necessary to have fair, practical, and clear rules for access and use of data. Access of use of data is one of the most important questions we also have to think about when we are talking about regulation, because data is one of the things we need for everything to develop new products. When we are talking about AI, we are talking about the tool which needs data for really building up good new products, or not so good ones. So that's the question then of regulation. What we also have to think about is how infrastructures have to look like, how the cloud capacity should look like. So I think when you take a look at this picture, you see data, it's not only one kind of regulation, it's a very broad picture you have to take into account. And as I already said, when you're looking at that and what the European Commission is already producing in this part, I always say, okay, saying to be a leader is easy, being a leader is not so easy. So therefore, that's what we are working on, because that's now also the question on us as regulators. Can we do business as usual, or have you think about? So coming to that, this data-driven businesses are forcing us as regulators. Regulation has a crucial role on this, and there is now the discussion we are in. Because coming back to what you yesterday also mentioned, how much regulation do we need? Do the markets make the regulation themselves? That's the similar. Yesterday we talked about capitalism and ideological parts. Looking at the bit, what we know, and what we see as regulators is that there is a missing framework we need, where we can work in and where we can develop all these things. Because one thing is the DSA, the other thing also the other acts we talked about. We have to develop this, and as we all know, too much. Auf Deutsch sagt man, zwäng und zu viel ist nur zu. I think in English it's too much or too less, it's the fool's guess. So I would say that's the explanation of that, what I said in German, and I think we have to think about this. So coming to the net, access high quality data is essential for high performance robust AI systems. Coming back to what we all talked about, AI in the past days, what Mr. Forgó also in his first presentation discussed about AI. Is there too much? Is the right? Is there the wrong regulation? Do we need another regulation? So that's what we are thinking about. At the end, all these questions, we see data is the raw material, AI is the production process or the tool, and the services we get out of it are the products. And now is the question, at which stage of these three parts you have to start the regulation, and at the end, who is then the competent authority on this? This picture only should give a short overview. When we saw it, it's really short. I have this picture at home. It's much broader. It's along, I would say it is 1 meter and 1 meter long, because in much more details. That's only the short version, which I tried to bring on this. What you all have to think about when you're talking about data regulation. You have on the one side the European data strategy, and you have this European AI strategy. They are interacted, and then you have all these different acts around. And now that's the question: who should do this regulation? Because when you look at that, you see there would be nobody who has the experience, the know-how, and the resources to do everything at all. We have sometimes also the discussions, and the European Commission also also thinks about to have something like a super regulator. That would be a fine thing to have. This super regulator who then can deal with everything, with DSA, with data protection, and all these AI questions. But at the end, looking at a country like Austria, we have several competent authorities in sector-specific or in specific topics, and they all have their experience, and they all have all the experts you need. And that's a real practical question now, how you should handle this. They are the experts in these sector-specific regulatory authorities. And when you build up it new for all of this, you have to double it either. That's the question, either to double it. The next question is either to build it up in one, put them together in one big regulator, and the third part is that these regulatory authorities work together and have a process, and that's still missing on the European level and the European legislation, that there's a clear statement how to manage this, how to do this. So that's what we are missing, what we are talking about, and what we have to develop, this cooperation and coordination between the different bodies. Because everybody of you, if you're working for a company, it's not very satisfying if you get a regulatory decision of perhaps of my authority, which says, okay, it's from telecommunications law side, it's okay, and on the other side there comes the competition authority and says, okay, no, that's not okay, you are not allowed to do that. So therefore it's very close and very important to work together up front, and then making decisions for the businesses, for the consumers, and so on. We already had another example, which is now very actual, where it was in the telecommunications law, where it was in regarding sharing and working together between operators. We introduced the so-called Article 85 in the telecommunications law. It was we developed this as a regulatory authority, where it was decided that before the Telecoms Commission decides, they have to work together in specific cases together with the competition authority and the Kartellanwalt. What's the English word for Kartellanwalt? Federal Attorney of Competition, or something like that. The Federal Attorney of Competition to work together with those, and then the Telecoms Commission makes a decision with the input of those two authorities, and now the operators get one decision which is agreed by all the other authorities, so they have the security need. And especially in these cases here, we need really much more cooperation and coordination on this. And just to show it a bit view, when you're talking about regulation now in the data field, you have to look at these three main points. That's a very rough description of that, but protection is one of the things. The other thing is the competition and the governance, how to handle it, how to do it, and it's mainly on the public. Here's more the public side, that's the private business, and here's the consumer and personal data issue. So it gives only a rough insight how to look at the regulatory world in the future. When you come to the next picture, you see in regards of the regulations we have now, which type of data is affected when you're talking about. With all this GDPR is mainly personal data, here is mainly non-personal data. Data Act is regarding privacy. You see here, you have a very, very broad picture in this case. And now I think I should speed up a bit. Just to say it, beginning with the GDPR, I don't want to explain it. You have these authorities to handle with this. This is the National Data Protection Authority, the European Data Protection Board, and the European Data Protection Supervisor. As you see, all these groups from the European side are also part of the European high-level group. So the European Data Protection Board and the Data Protection Supervisor is also, for me, part of this DMA high-level group. So on the European side, you have always groups where these different sectors come together and work together with the Commission, which is a step in the right direction, but not the final one. Looking at the Data Governance Act, which will be very, very important within the next weeks or times, because there should be a legislation already done till the end of the year, although there's not even a data strategy of Austria, which would be needed to do something like this. What we can say here, the directive, the act is talking about these competent bodies to assist. The question is, who are the competent bodies? Regarding the data governance, I can tell you there will be a leading role of the Institute of the Statistik Austria as a regulator and discuss. They will be here on a leading part to become something like a data, how did they call it? Yeah, I don't know the name again, so, but they will be the data supervisor in this case, and they are now coming also to us, building up cooperation, cooperations to bring forward this regulation, because here we are very, very at a very late stage in Austria, so we are very late in bringing it into force. The other thing is regarding Data Act. Here, many one or more competent authorities are involved in this, mainly the data protection authorities and competent sectoral authorities. It's like also us. We are because the Data Act explicitly says there should be authority in regarding switching or interoperability, and in this case there should be an authority experienced in the field of data and electronic communication services. So for Austria, this is RTR Telecoms. We are talking about now to bring that forward. One thing which was not so good, that in Austria for more than 18 months nobody on the political side was clear who is responsible for the Data Act. So that was the reason that nobody in Brussels from Austrian side talked at the working groups with the Commission by developing the Data Act. So Austria was not existing in the Data Act we have to now to handle. Now we know it, now it's the Ministry of Finance, but it's too late because we only have to bring it forward, and we can be but that's one of those things. So there's so many acts, so many decisions, and at the end you don't know who is really at the end the responsible one for it. So that's regarding the Data Act. And now coming to the end from my side, what are the new tasks for NIAs like us in this case? Reduce regarding the Data Act is reducing barriers to switching. Interoperability of cloud services is one of the big aims, because also at the end, and you have always be aware of this, it's always we are talking most times about protection and to avoid risks and so on. So that's when we are talking about regulation, many people think about how to avoid risk, how to maintain existing systems, how to have remedies against some actions to be set. But nevertheless, the main task and the main obligation of regulation should be to look for a fair and competent competition between the players in the market. It's always also a question of competition, and open competition is at the end, from my point of view, the answer on the right regulation at the end. So therefore, when we are talking about interoperability, it's the competition which helps that cloud service providers are open, having fair practices, don't make lock-in effects for their customers, and then because everybody of you know, when you're using cloud services now, when you're using apps now, you are locked in. But that should be changed in future, and at the end, this will help because the competition will force the companies to have really good offers for the customers, for the businesses, because they want to keep them stay in their services. If interoperability is open, they are always threatened that they can lose the customers. Now, WhatsApp has no problem. They will not lose their customers. As long as everybody uses WhatsApp, everybody will use WhatsApp, and you can't put your data on different services, European services, and so on. And that's a bit the aim behind of this. So I'm personally convinced that at the end, competition and maintaining and developing competition as a regulatory job is the best way to reach all these solutions for the problems we are talking about when we are talking about regulation. So also cost accounting is being dispute resolution, so it should be part of the knowledge of the know-how regulators should bring with. And as you can read between the lines, and as I said, like RTR telecoms, we think that we have all the basic know-how and knowledge to do this in the future, to doing this coordination job. So personally, I don't want to be an AI authority, I don't want to be a DSA authority or a DMA authority, but what we think there should be some independent coordinator which coordinates the upcoming discussions and upcoming questions within Austria. So that's a bit the story you have to think about when you're talking about and thinking about the data regulation, when you're thinking about what's coming up and how can we solve solutions. It's not avoid only looking at one part of this story. The story is a broader one. Perhaps keep in mind this mind. It's a broad picture when we are talking about regulation. It's need and it's necessary to really discuss and work together on the regulatory side on national level, but also on the European level. And I think that will develop within the next, I would say, 2 to 5 years. So we will see there will be a new kind of regulation we don't see already now. So thank you, and I hope I did it within the time.
So thank you very much for these insights in the practical implications of the emerging regulatory environment. I would like to turn to Nikolaus Forgó now. It was already mentioned on Wednesday that he doesn't need any introduction here. I nevertheless want to say some words to Nikolaus Forgó. So he's professor of IT and IP law at Vienna University. He's head of the Department of Innovation and Digitalization in Law at the Vienna Law Faculty, and he's also head of the postgraduate program on Media and Information Law. Franz Stefan Meisel already mentioned on Wednesday that he's the go-to person if you have any question in IT law in Austria, but that's not only true for Austria. If you take a look at his homepage, you will find that he's partner in, I think it's more than 15 international and interdisciplinary research projects. And if you have been a member in only one of these research projects, you know how much work that is. And I'm always wondering whether Nikolaus Day has more hours. At least it has more hours than my day. So please join me in welcoming Nikolaus Forgó at the
I think I will stand up as well, if that's okay, because you can then see me better. But the downside of this is that I don't see my notes. So if I make a break or so, this is because I don't remember anymore what I wanted to say. My apologies for this. So thank you very much for giving me this opportunity. And I need to start with a German term here, which is Vorrede, which is in English something like preliminary or introduction remarks, meaning that I will refer in some parts to some German or Austrian issues, and I apologize that I think one or two of the slides are in German therefore, but I will give you a translation of what I'm talking about. Thank you for this very kind introduction, and I will focus on something which was interestingly, in my view, not yet mentioned during those 3 days, although I think it will further darken the picture we are in. And that's about security, in particular information security. I'm not an expert in security at all, but I do know a little bit about information security. And I think that we will need this also from a political picture, or from a political perspective here now, to make the picture a little bit more complete. And let me just repeat again with this slide that I showed you already 2 days ago, and you might remember that I insisted on the fact that TikTok is the new kid around the block. And I then said 2 days ago that TikTok is a competitor when it comes to AI and so on. What I did not really refer to then in full detail are the privacy policy details of TikTok. And I would invite you just for a moment to read them together with me here very briefly, because what you read when you read this, and nobody reads it, and even if you read it, it doesn't change anything, right? You still install the app. So if you read that, and if it changed anything in your behavior, you would have read that in the terms and conditions of TikTok, it's openly said that, of course, taking into consideration GDPR and all the other stupid rules nobody wants to read either, of course, taking them into consideration, they explicitly write that there is remote access to all kinds of user data of all users, including people in mainland China having access to your data. So this means every single of those kids running around here is in a situation where they agree to transfer of their personal data, of course GDPR compliant, inter alia to mainland China. And I would consider this a risk, also an information security risk and a geostrategic risk and so on. And I would appreciate if that were on the agenda of European legislators and of European policymakers. And importantly and interestingly, TikTok has come on the radar of European policymakers, including the European Commission, because the European Commission is launching press releases like this one here in this matter. And I don't want to criticize that they are doing this in particular. What I want to criticize is the wording, right? So Commission strengthens cybersecurity and suspends the use of TikTok on its corporate devices, as if that were a significant contribution to the fundamental issue, which is there are millions of people using this on their phones every day. By the way, ironically, you will find all kinds of European policymakers still on TikTok, despite of the fact that they don't allow their staff to use that any longer. And I start with this because I think this conflict of goals, or this fundamental problem that things are more complicated and that you should need to do things differently and simultaneously, is in a way the starting for me for this presentation in order to give you a very brief overview about where we stand when it comes to regulation of information security in Europe. And just like in any other of the fields that we were debating in the last 2 days, the legislator has been outstandingly active also in this domain. In particular, we have the so-called Network Information Security 2 Directive, which is the one I will mainly talk about. And then we have a proposal for a regulation laying down rules to prevent and combat child sexual abuse. That will be the second piece I will mainly talk about. And let me just start with a personal remark. I've been working on and with the internet now for more than 30 years. And whenever something which is critical or politically discussed enters the scene, child pornography is with it, right? So because this is so obviously evil that it can be used for every argument that you want to. And that's true now for the last 30 years, and we are still in this situation. I will come back to that in a few minutes. So let's start with the NIS2 directive, which is already in force and which is to be transposed until the 17th of October 2024. Quite soon, by the way. I'm not aware of any major or significant movements of the Austrian legislator in this domain, apart from the fact that the ministries start to compete who is going to be the one in the leading role. So just like with the DA and DGA, where it took us months or even years to identify the leading ministry, I see us running into a rather similar situation here. In this case, it's the Federal Chancellery on the one hand, and the Ministry of the Interior on the other hand, who might have stakes in the game. And if you think politically about that we are going to have elections next year, and there might be changes in the government that might be also foreseen already now by people in the game, it might be interesting to hear who is going to be the one taking care of information security, and whether it's going to be the Minister of Interior. So please fill in a name of a person you might think about, or the Chancellor. Please fill in a name of a person you might think about. And we are talking about 2024, so that's quite soon. So we are late with this. We are late, different from the Germans, by the way. And so this is one of the German terms that I'm using. I have one rule of thumb, which is you identify a bad law in many cases already by the title. And this is a very nice one, because the German transposition of this is called, or the proposal for a German transposition of this is called NIS 2 Umsetzungs- und Cybersicherheitsstärkungsgesetz, which has a beautiful abbreviation, NIS 2 Umzugsregel, yeah? Right, so in English this is transposition and enforcement of cybersecurity in a law. So this is the German proposal. That is already on the table and that you can have a look into. And this is what you need to know about the directive and also about the law. There is a law in Germany on security and information security. It has 15 articles so far. The new proposal now has 65. So 4 times more, just if you just take the text, which is stupid, of course, but it gives you some kind of indication, 4 times more of articles that companies that or administrations that are concerned about or that are affected by this law will need to take into consideration if this should make it through the German Bundestag and Bundesrat. And the reasoning for this other explosion of law is possibly already given by the first, actually by the second recital of the NIS 2 directive. So just like in the DSA, where Bernhard rightly mentioned that there's quite some explanation about the reasoning behind, this is also the case here in this case. And the reasoning in the second recital of this directive starts with the following statement. Since the entry into force of the first Network Information Security Directive, which is the NIS 1 directive. It's this one here, 1148 of 2016. Significant progress has been made in increasing the union's level of cyber resilience. So the statement is, due to the law, and since then, Europe has made significant progress when it comes to cyber resilience. Let me just make this here a little bit more interactive. Who of you agrees with this statement? Okay, case closed, right? Case closed. Okay. I could show now again Thierry Breton somewhere standing around, but I will not do that. Instead of this, I will just refer to this. It's an explosion of laws because it's going to proceed or continue with this success story that we saw already in this one. And potentially affected by this is more or less everyone who is in a critical area. What that is another issue I will talk about in a second, with more than 50 employees and more than 10 million euro annual turnover. So it will be a lot more of companies and a lot more of industry being affected by this. In particular, research institutions will be affected by this. Public administration and digital infrastructure providers will be affected by this law, a lot more. So if you are in public administration, it's quite likely that your organization is a target of this. If you are in any kind of digital industry, it's also very likely that you are affected by this. But also if you are just running a postal service or something, it might be that you are within the scope of this. And what then needs to be done if you are affected is beautifully described in, for example, Article 21 of this. And I will not read this together with you. There are some words which are highlighted in red. And the reason why they are highlighted in red is that this is the lengthy version of something which lawyers normally tend to drill down to be careful, and it depends what this really means, right? So whether this is state of the art, or whether something is appropriate to the risk posed, or whether something is proportionate as a measure, is something which obviously needs to be decided on a case-by-case basis. So the key message of this is, it's dangerous, and be careful, and be aware of the risks, but we can't tell you any details. More on this, if you want to read a little bit more about this, all kinds of, so for example, I would really invite you, because I fundamentally don't understand this, I would really invite you to consider together with me what this really means, that if you are affected and you need to undertake all those measures, what you should then do if you want to implement basic cyber hygiene practices. So what is a basic cyber hygiene practice? I don't think that it's washing your hands before sitting in front of the computer. So interesting to interpret this in the domain. And there's plenty of other things which are as interesting, just like the basic cyber hygiene practices. And of course, just like in any other of those acts, it's again the Commission self-authorizing the Commission to come up with further details. So again, on top of all this, the Commission will have to implement, to adopt implementing acts, bringing probably even more of those details on the table. So let's assume then that you are affected. Let's assume that you took all those measures. And let's assume then that you have an incident, right? Something is happening which is strange on your network, and you need to report that. According to this directive, it's not enough to provide just one report. You need to provide up to 4 reports on one incident, right? You have a preliminary report when you identify it. You have a report to deliver within 72 hours after having identified the incident. You have then to give an intermediate report about the progress made upon request of the authority, and you have to make a final report within 1 month on one single incident. So this means, I had a very interesting conversation yesterday during lunch, I think, about what such a report means. A report means that your company is at hold, right? At least major parts of your company, your IT department, your legal department, your compliance department are on hold because they don't do anything but providing material for such a report. You need to do this now 4 times for one incident. And if you then report, interestingly, one of the things that you need to take into consideration is that you need to provide the authority with proof that you have implemented the relevant cybersecurity policies that I mentioned before, right? So you will need to report not only that you were in line with the law, but you will need to prove this. You will need to have all this in writing. So just like in GDPR, the main outcome of GDPR was not that data protection is more fundamentally protected or more important in Europe at all. It's that plenty of paper was written on pretending that data protection is taken more seriously than before. And this is going to happen exactly, this is my prognosis, this is going to happen exactly in the same way here because of the implementation of this accountability principle 2.0, as I call it. And the risks, just like in the success story of GDPR, are significant, so there is quite an important incentive to follow this. And this is, by the way, also from those of you who are into legal language, this is a very funny example because the risks are high. And interestingly, member states have to guarantee that the administrative fines have a maximum of at least a given sum, right? So you need to implement a maximum of at least, which means that you can feel free to take 10 times more as a maximum fine here, which is, I like that wording. Okay, and now to the German text. So this is the German original of the German draft. So this is not the law yet. And this is my translation of this unofficial German official text. I used DeepL for this, by the way, but I did some corrections to the DeepL suggestion. This is interesting, in my view, because what we have seen and what this law knows without telling us, and this is the second provocation of this presentation, what we have seen and what this law is telling us is opposite from recital 2. We have a very significant cybersecurity problem in very many companies in Europe and in very many public administrations. And as this is the case, and as you are the legislator, one of the instruments that you could use to try to make this better is to make the people running the administration or running the company even more strictly reliable and liable for what is going to happen here. And this is, in my view, the most extreme version of this that I have ever seen, because what you see here now is, it's also interesting perhaps for the corporate lawyers in the room, if there are any, what you see here is that they are really drilling this down to make the head of the company liable and therefore reliable by them personally asking to take measures. So the business managers, blah, 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 have to take care of, are obliged to approve the cybersecurity risk management. So if I was not mistaken, I saw the president of the Austrian Federal Supreme Court yesterday in the church. She was there. So imagine her signing off the security policy of the federal court, because this is probably her who will need to do that. And it's not allowed any longer to commission this to a third party. So somebody like her, Professor Lovrek, will be the one who will then need to take the responsibility that all these unclear terms, right, appropriate, proportionate, state-of-the-art, etc., are to be in place in this. And on top of this, if you violate the obligations as a CEO of the company, in this case, you will be held liable for the institution, and the institution may not waive this liability, right? So even if you have in your personal labor contract that you are not a cybersecurity expert and that you unfortunately therefore can't tell people what exactly this means and what they should do, it still means that you are the one who will need to pay for this. And just to make this even clearer then, imagine Professor Lovrek needing, because she must go there, needing to go and to participate in cybersecurity training to acquire sufficient expertise in the domain, right? So people like Professor Lovrek, or I don't know, all the CEOs that we saw yesterday, they are going to seminars, which is really good news for seminar providers, obviously, because you will start with, this is a mouse, this is a computer, and you can lead them then up to be cybersecurity specialists at the end, and that will be a rather impressive and nice business area, I think. So if I had money to invest into, I would invest into cybersecurity educational institutions at the moment. This will be a big thing. So that was part one. Part two, don't worry, will be much shorter. Part two now is on this child abuse thing. As I said, since I've been in this field, this is the argument that is constantly coming when surveillance is supposed to be increased, right? Whenever any police authority asks for more competencies, one of the key arguments coming within 5 minutes is child pornography and child abuse. And this is happening in a completely different field now, again, because there is this proposal on the table for a regulation on better protect children from child sexual abuse material. And there is plenty of debate on this ongoing at the moment, and the debate is on the one hand legally driven, so people argue that there are all kinds of legal issues that are not properly covered here, and on the other hand it's technically driven, the debate, because the technical part of the debate is that if this is going to be law, one of the very few basic security infrastructures that we have agreed on after 30 years of debate, technically and legally, which is end-to-end encryption. End-to-end encryption meaning that a man in the middle, an attacker in the middle, can't decipher what you communicate about because it's encrypted and nobody can decipher this. So if this comes into law, then one of these very few fundamental solutions we have so far, which is end-to-end encryption, will be weakened or will be made impossible. This is the main claim here. And this is a claim which is not made by me here. And that's my third remark on why I think that European policymakers miss the point. What I'm referring to now in the next 3 or 4 slides is an opinion of the legal service of the Council, so one of the legislative bodies on the European level, and it's their legal service. So I would assume that this is something which is hopefully objective, right, in the sense of that they want to help the legislator and at the same time they want to tell about the risks. This is a leaked version. By the way, this is one of the funny things also in European politics, that whenever things become different, miraculously leaked versions appear and nobody really knows where they are from. I don't know where it is from and I don't know whether this is true, but I think there are quite significant indicators that this is a proper document. So the legal service of the Council discussing this issue of end-to-end encryption to be weakened when it comes to child sexual abuse. You can read the document, I have put the reference below. And again, without bothering with too much of text here, the main statement here is the screening of content communications if this would need to be effective, there are 3 options here. Option 1, abandoning effective end-to-end encryption. Second, introducing some form of backdoor into encryption. right? So that you have a key allowing you to decipher this. Or third, accessing the content on the device, so that you have a Trojan horse on your device taking the message before it's ciphered. That would be option 3. These are the 3 options according to the, and I think it's a quite proper description of the situation. These are the 3 options that you have according to the Council's legal service. And therefore, they say it appears that the generalized screening of content of communications to detect any kind of child sexual abuse material would require de facto prohibiting, weakening, or otherwise circumventing cybersecurity measures. So again, the legal service of the Council makes the statement that if the European legislator puts this into law, this is weakening fundamental cybersecurity measures in Europe. And at the same time, we introduced the NIS 2 directive, right? And again, then at the end, the Council says there is a serious risk of non-compliance of these measures with the nice principle of proportionality, which is the nicer word for it depends, and be careful, that we talked about before, right? Of course, the Commission now starts writing papers that all this is inappropriate and that the risks are not that serious, and which I could not go deeper into this presentation because it's not my main point. My main point is that we have this fundamental issue here, which is that we don't know where we want to run to and what is the direction that we want to run to, also when it comes to cybersecurity. Thank you very much.